Yes.
Item number 1.
You are ready to proceed with the matter?
Yes, my lord. I have.
And your other side is also ready?
Yes, my lord. I have supplied the paper book.
All right.
Comparison with
Pass
judgments.
over at the first call. Make a first call. Keep the papers with you. These item numbers 1 and 2.
No, item 2 is different, Your Lordship.
Only one, my lord.
Only one. Okay. Call to you.
Item 2, Your Lordship, we have filed our former paper book, Your Lordship. I'm praying, Your Lordship, if the matter can be taken up some other day, Your Lordship.
What is the matter about?
This is a regarding promotion, Your Lordship.
My lord, my only,
She has already retired
my
now.
lord, only thing, my lord, the retirement benefits and all could not be dispersed because of this case. Only, my lord, at the earliest, my lord. If not this week, next week.
Promotion means that matter where during service the quota was revised and...
No, Your Lordship.
No, in case of promotion, then she has been reverted.
Oh, this is item number 2.
Lordship, yes.
When do you want to do the matter?
Well, if it will be taken up, my lord, next week, because there's some urgencies there. Next week.
Not next week, Your Lordship. If
Please agree on a date, which
it
is
come on-
not very far off.
on 3rd, Your Lordship, 3rd
My lord,
or 4th, Your Lordship.
third, what time we have?
All right, 4th March.
My lord, only, my lord, third, fourth, my lord, passes. 2 weeks, my lord, in March, I'll have some personal difficulties. Then let it come up after 12 March. Because I will be
Have
out.
we started hearing the matter?
No, not yet, Your Lordship.
All right. By consent of learned counsel for the parties, list this appeal for hearing on 19th March.
19th March, Lordship.
Acknowledge.
Highly apply, Your Lordship.
Item number 3 and 4.
Yes, please.
My lord, in this matter, the appellant has submitted an affidavit as was ordered by your lordships on the last date. I just want to make reply to that.
Give it.
Yes, your lordship wanted the minutes of the meeting to be produced before the court through an affidavit. That they have done.
Kindly see the order of your lordship of 6 February 2025, Lord. This is the issue where the learned single judge has returned the finding that there was no technical assessment.
Yes.
They have filed now the affidavit, my lord. I received the copy yesterday. So if your lordship kindly grants me some time, my lord, I can file a short reply. Because this aspect of the matter was not open before the Honorable Single Judge. This is some factual revelations coming for the very first time in the appeal.
That is within their special knowledge. How will you deal with it in your affidavit?
My lord, certain things have been placed on record, certain in the minutes, where the aspect of qualification is highlighted. So I just want to place some materials on record. It is also it is also about some of my deficiencies in the tender process.
Because meeting is their meeting.
Yes.
You were not part of the meeting.
Yes, we also attended to the meeting.
Technical meeting.
Yes, but they say that certain
Bid, my lord.
on the opening of the bid we were present, but in the proceedings of the meeting, my lord, they have now highlighted that there were certain deficiencies which were
No,
required.
when the technical bid was being evaluated, you were called.
No, in that evaluation that we are not called, and the evaluation has also not been disclosed in the affidavit. Only certain observations made by the committee has been disclosed.
My lord, if your lordship kindly see your lordship's order at page 2 of your lordship's order, my lord.
No, it is all right. We will not shut you out. But then It is neither within your knowledge nor derived from information. All submissions before the
My
court.
lord, I know about my lord,
So, how would you be able to deal with this this affidavit filed by the government?
my lord,
regarding-
there are certain revelations about my beat. So on those aspects, my lord, I just want to file an affidavit.
All right.
Lordship, may I just come in, Lordship, here?
Yes.
Lordship, I'm in item number 4. I'm the person who the award was given to me, the work order. Lordship, it is a two-bid system. The first is the technical bid, second is the financial bid. In the technical bid, Lordship, all the representatives and the tenderer were present. They have put their signature after closing of the technical bids. They were satisfied that once they put the signature in the forms, they were satisfied. Then it is projected that this whole bid was opened on 26 July. It is not like that. According to the bid document, Lordship, on 26 July, only the technical part was opened. Only the technical part was open. Only in September, the financial bid was opened. When this technical bid went through, they put a signature on that, all the tenderers, Lordship. There's a sheet of paper that all have attended. When they put a signature, they have accepted the same. Because they all qualified, Lordship. Because tender document says in the technical aspects of the matter, there are certain criteria, certain things that requires Lordship, and they all fulfill it. Where is the question of evaluation again, Lordship? After that whole system was done, then only you can go to the financial bid, Lordship. And financial bid was open. The moment they see that they were less, they come again with representation and all, making out a case that there was no technical evaluation. Whereas, Lordship, before going to the financial bid, the technical aspect was gone within. And they put, Lordship, if you say Lordship sees the file in the technical bid, that their signature is there.
All right. Please take down. Further to our order dated 6th February 2025, the appellant, Meghalaya Power Generation Corporation Limited, bracket MEPGCL, bracket closed, has filed an affidavit disclosing the deliberations and minutes of the meeting held on 27 July 2023. When the technical competence of all the bidders was assessed. You're for Odimar.
No, Lordship, I'm for the
Taiwan.
type inventory. I have got the work order. I'm the successful bidder, Lordship.
Then why have you preferred an appeal? Taiwan,
Because the single batch order set aside my work order.
why? Full stop. On the prayer of Mr. S. Dr. Learned Senior Advocate, appearing for Odimar Samsad, leave is granted to his client to file an affidavit in opposition to the said affidavit. Full stop. Copies may be circulated to all the parties. Such affidavit may be filed by when, Mr. Doctor?
Lord, within a week, about by next week, my lord, we will file. Huh? Today is 17th.
May be filed by 25th February. Next line, we also grant an opportunity to MEPGCL and Taibil Warjari to file a short rejoinder to the said affidavit if they so deem fit and proper. You can also file a rejoinder.
Yes, my lord. Yes, my lord.
Why?
1 week, my lord, there.
Fourth March. List this appeal for hearing on 6th March.
My lord, on 7th or 5th or
5th March.
5th. Obliged.
Obliged.
Item number 1.
13th March, my lord.
Yes.
13th March, my lord. 7th March, I have some personal difficulty, my lord. 13th March, 1-3, my lord.
There may be holy vacation on 13th March. Not no, my lord.
14th is the red letter day. 13th?
13th may be holy vacation. My lord. I do not know whether it is there or not, but
No.
in Delhi.
12th matter has been fixed before your lordship. 12th matter has been fixed for hearing, my lord. 13th I will be there. I'll do it.
Fourteenth is 13th and 14th are marked as holy. My lord. I do not know whether it is
All right, 18th March.
obliged.
Yes.
Petition. My lord,
You wanted a discussion in the House on the audit report,
yes, my lord.
which was denied by the Speaker. This is
Yes,
the case.
yes, my lord. That was the case, my lord. And then, my lord, I have been just served the paper book from the learned friend just now. So I don't know whether, but anyway, my lord, I have served my paper book in advance, well in advance. But I'll be just served, just passed on here now. So
These are the judgments which have been referred earlier, my lord. These judgments have been, we have put in compilation form and we have handed over those judgments earlier also to my friend. Same set of judgments, but in one compilation.
Yes, yes.
yeah. So
Mr. Yobin, you proceed.
yes, my lord.
The point is very short. You
It's
tell
very
us
short. Yes.
the power of the court
Yes, my lord.
to interfere.
My lord. The power of the court to interfere, my lord, if it violates the fundamental rights, or if it violates the if the question is not only of the judicial procedural irregularity, then my lord can interfere, my lord. That was the case that I was trying to make up, my lord. In support of my contentions where the judicial review is permissible, my lord, if the subject matter is beyond the procedural irregularities, my lord, that I have submit my in the paper in the compilation of my judgments, my lord. The first judgment, my lord, that I would like to refer, my lord, has the compilation of the judgments, my lord.
Now, audit has been done, the payment has been made, as you said on the last occasion. Only the report.
Yes, my lord.
Now, what is the purpose of deliberating on the report? What purpose is served?
My lord, the CAG submitted its report, my lord, to the governor, my lord, to the governor. And in the report, my lord, in the report, I'll just take to the relevant portion of the report, my lord, just to read out. Where is the report? The report, my lord, reads as such, my lord, and I'll just read for my lord's benefit.
No, let the report be. What is the purpose? You wanted to discuss the report.
Yes, my lord.
Now, what would come out of it?
My lord, what will come out of it is because, my lord, 156 crores, which is avoidable expenditures, in spite of the advisory board, it has gone from the state's exchequer. So I wanted to bring this one so that, my lord, we can formulate, my lord, in the policies in the days to come, my lord. In the days to come, my lord, we can formulate policies, my lord, where we can where there can be a mechanism of check and balance, my lord. This is what my intention was, my lord. So
how did the money go out? Was there any grant by the legislature?
my lord,
At that time, the discussion should have been made. What will come out of the report? The report means they will check the accounts of the government and say that it is properly made or not.
my lord, before implemented of this scheme, my lord, whether in the legislature it was decided or it was passed a resolution to go for this is not there, my lord. This is of the owned, my lord. This is a scheme of the own, my lord. It's not something that was prior to the implementation or prior to bringing of this scheme. There was a discussion in the legislature, my lord, and where we have all agreed, my lord. It is not a case, my lord.
All right, decision was taken to spend that amount by the legislature.
My lord, the report says like this, my lord. I'll just state the headline of the report. Page 34, my lord. Page 34. This is the extract of the report, my lord. Page 34. Page 34 of the memo of appeal, my lord. It reads 3.1 or 3.3, my lord, avoidable expenditure. Despite advisory issued by Cabinet Secretary, injudicious decision of MEPDCL for awarding works under Sobhagya to contractors at the quoted rates resulted in avoidable expenditure of rupees 156.14 crore.
Yes.
So, my lord, this a report, my lord, Rule 120 or 130A of the business rules, my lord. It includes, when we say about a report, my lord, it includes a CAG's report also. And in Rule 130 of the rules of procedure and conduct of business, it says that when a report which is of grave public importance, then it will take precedence over all other reports.
MEPDCL?
MEPDCL, my lord, is a Meghalaya Power Development Corporation Limited, my lord. And this is a company, my lord. This is the PSU or the PSE, which is not even able to pay the pensionary benefits to its retired employees also, my lord.
So this money which is paid by this organization is in turn realized by the organization from the government.
Government, my lord. So therefore, my lord, this is of a very grave public importance when the department cannot even pay retirement benefits to its employees. You are getting dictated by a contractor at the quoted rates. Resultantly, an extra 156 crores gets expended, my lord. There is a reason why I wanted to discuss, my lord, deliberate in the house, my lord. So this was cartel on whose instructions, on whose directions, on whose request, cartel on the request of the Honorable Chief Minister. So therefore, when the speaker was exercising, rejecting, he was not exercising his own independent judgment, my lord. He was getting influenced. Maybe they had some more things to hide that I don't know, but this was such important issues that needs to be deliberated and discussed, my lord. And as a legislature, Article 194 gives me that privilege, my lord. So where I am aggrieved is because my right to discuss, deliberate, to raise an issue under Article 194 that has been curtailed, my lord. This is where I say that I am not challenging the procedural irregularities. I am challenging the curtailment of my right as a legislature, my lord. My lords are very much aware, my lord. There are two articles, my lord, Article 14 and Article 149, my lord. Or 194, I'm sorry. Article 14 is available to all, but Article 194 is specifically given a privilege to a member of the legislature to raise an issue of public importance, my lord. And one of the very important point here also, my lord, is this. They say the subject matter, why they reject is they're saying the subject matter is under the scrutiny and examination of the PAC, my lord. Rule 241 gives the functions of the committee, my lord, of the PAC, my lord. But in Rule 241, it never gives that when the subject matter is before the PAC, you cannot raise the discussion in the house, my lord.
Rule
241, my lord.
article.
No, this is Rule 241 is of the rules of procedure, my lord. I have already supplied a copy there.
When was this decision taken?
This decision to disallow me.
Yes.
This decision to disallow me, my lord, was taken on 19 February 2024, my lord.
Is it still open to discussion now?
My lord, the reports, my lord, The reports are still there, my lord, in existence, my lord. This can be discussed in the coming house, or in the coming session also, my lord. And the PSC has been examining since 2022, my lord. And we are here in 2025. Winter sessions are about to start. Anytime. Still, the PSC's examination has not completed, my lord.
Where is the decision to refuse?
Decision to refuse is 19 February 2012, 39, page number 39, my lord. Page 39. May I just read, my lord? Subject disallowed motion. With reference to the subject cited above, I am to inform you that as per information received from the Honorable Chief Minister by so-and-so letter, 19 February 2024, a copy of which is enclosed, that a special motion submitted by you on 15 February 2024 has been disallowed by the Honorable Speaker since the subject matter is still under the examination of the Public Accounts Committee, Meghalaya, Legislative Assembly. This is for your kind information. The only ground they've taken is two. One letter from the request from the Chief Minister, and the second says that PSC. This is where I was telling taking my lords to Rule 241, my lord. Rule 241 of the Rules of Procedure and Conduct of Business.
Function of Committee on Public Accounts.
Yes, my lord. Function of Committee on Public Accounts, my lord. So,
What does that rule say?
my lord, this gives what is the functions of the public accounts, and it says that its duty is to scrutinize the appropriate accounts of the government and the report of the Comptroller and Auditor General thereon. It shall be the duty of the committee to satisfy itself that the money shown in the accounts as having been disbursed were legally available for and applicable to the service or purpose of which they have been applied or charged. And number B, my lord, it says about the expenditure conforms to the authority which governs it. C, that every reappropriation has been made in accordance with the provisions made. And also it gives a state to examine the state of the statement of accounts showing income, expenditure, etc., my lord. And also it gives to examine the statement of accounts showing income and expenditure of the semi-autonomous bodies.
The report is filed by this committee.
No. The report is filed by the Comptroller and Auditor General of India, my lord. And this was filed in exercise of the power given under Article 151, my lord.
Yes.
Article 151, clause 2 says this, my lord. The report of the Comptroller and Auditor General of India relating to the accounts of a state shall be submitted to the governor of the state, who shall cause them to be laid before the legislature of the state, my lord. So this was done.
And passed.
This was done, my lord.
Then why did you not put it up for discussion at that time?
My lord, at that time, at that relevant point of time, my lord, I have moved the application, my lord, under special motion, my lord. That was rejected.
So when was it placed before the legislature?
My lord, I'll just give a list of the dates, my lord. Where is it?
Just give that date.
Yes, my lord. This was placed. My lord, this was placed on 22nd September 2023, my lord. And 22nd September 2023 was the last day of the autumn session of 2023, my lord. It was the last day, my lord. So, having placed this one on the last day, none of the legislature could get an opportunity to raise. So, the first opportunity that I get was on 29/01/2024 when it resumed, my lord, for the next assembly meet, my lord, or the next session, my lord.
Placed before assembly when?
Placed before the assembly on the last day of the autumn session of 2023, my lord. That is on 22nd September 2023.
Yes.
So, being the last day, none of us has an opportunity to move motion. Therefore, the next opportunity was the next session. So, immediately when the next session was called for, on 29/01/20, I have submitted the application on 15th February 2024. Because this is the first session after the last autumn session. So the first opportunity that I got, this is the time that I've taken the opportunity and submitted my application, my lord, for a special motion.
February.
Yes, my lord. 15th February, my lord. 2024, my lord.
Yes. And rejected on 19th February.
Yes, my lord.
You have cited these cases.
Yes, my lord. I have cited these few cases, my lord, where
2007 SCC 184.
yes, my lord. Volume 3, 184. It's in the
Volume 3.
Yes, my lord. It's on the compilation, my lord. This is a yellow color compilation that I've submitted. Raja Rampal 2007 case, my lord. That's from page 1 to page 281. The relevant paragraphs that I have quoted is, my lord, 360, 360.
Para 360.
My lord, para 360, that my lord will find at page 164 of this paper book, my lord. And 366.
Is page or para?
This is para 360 and the page is 164. I've in this on top I've written page numbers by pen, my lord.
The paragraph numbers are referred to.
Yes, my lord. Page 360.
Not page, para.
I'm sorry. Para 360, my lord.
You have referred somewhere to which paragraphs of the judgment you are referring to?
My lord, these relevant paragraphs in the I have
360, 366. Any other paragraph?
360, 366, and my lord, does 431, my lord. 431, these are the summary of principles relating to parameters of judicial review in relation to exercise of parliamentary provisions, my lord. 431. 431.
Not 360.
No. 360, 366, and 431.
All right.
These are from the Raja Rampal, my lord.
2016, 6 SCC 82 is the next case.
2016, my lord, this is paragraph 18, my lord, 18.4.
In these two cases, what is the proposition?
The first case it's the power of the judicial review, my lord, when on the decisions of the speaker or the chairman. And the second one is, my lord, the privileges, Article 194, which I was pleading, my lord. 2016 is regarding Article 194, my lord.
What is 216?
216 is regarding Article 194, my lord. The privilege, the privilege of the member, my lord.
Okay, 1964 SCC online.
1964 is a paragraph 60 and 61, my lord. 334.
What is the proposition?
The proposition in these ones is, my lord, this is a combined, my lord. One talks about the privileges under 194, and 61 talks about the provisions, the immunity under Article 212, my lord.
Then 2020.
And 2020, my lord, this is the this is paragraph 152, 152, 153, and 154, my lord. So this one, my lord, in support of my contentions, where I was saying that the speaker should be a neutral person. So this judgment, it's in support of that contention, my lord.
So these are the four cases.
4 cases, my lord.
You have cited.
Yes, my lord.
So these are all your arguments?
These are all my arguments, my lord.
Yes. Yes, Learned Advocate General.
Yes, my lord. My lord, if I have understood my learned friend's submission correctly, his submissions are twofold, my lord. One is, my lord, that he has a right to raise the motion or discuss about the CAG report, even though the matter is pending before the parliamentary PAC, the Public Account Committee, my lord. That is, there is a Public Account Committee which examines this CAG report, my lord, and thereafter it gives its comment to the Assembly. There is a rule laid down in the Assembly, my lord, for examination of CAG report, my lord. And rule is 241, my lord, and there is a process for examination, and then its recommendations are placed before the Assembly, my lord. This is first submission. What he says that he has right to get the report examined even before the recommendation is made by Public Account Committee under the rules and constitutional scheme. That is his first submission. Second submission, which my friend has made, my lord, that there is the 212 bar will not be applicable because he has a fundamental right to speech under Article 19(1)(g, my lord. That is what he says, my lord. So before I take your lordship to the rule part, my lord, kindly see 241 of the Assembly rule, my lord, which my friend has placed before your lordship, 241. May I place 241, my lord? Committee on Public Accounts. 241, my lord. And 242 also, your lordship may kindly examine. 241 and 242. (241), my lord, starts from, my lord, Committee on Public Account.
Yes.
241, my lord, provides for examination of CAG report, my lord. And kindly see 241, my lord. It clearly says, my lord, that there will be Public Account Committee.
Yes.
There will be a Committee on Public Account for examination of accounts showing the appropriateness of sum granted by the Assembly for expenditure of the Government of Meghalaya, the annual finance accounts of the Government of Meghalaya, and such other accounts laid before the Assembly as committee may think. In scrutinizing the appropriation accounts of the Government of Meghalaya and report of Controller and Auditor General, it shall be duty of committee to satisfy itself, my lord. And there are various, the money shown in the accounts as having been disbursed were legally available for and applicable to and service or purpose to which they had been applied or charged, that expenditure conforms to the authority which governs it, that every appropriation has been made in accordance with the provisions made in this behalf under the rules framed by the competent authority. It shall be duty of the committee to examine the statements of accounts showing the income and expenditure of the government, trading and manufacturing and project concerned, my lord. These are listed, my lord, from A to D, my lord. Now kindly see 241(4), my lord. That if any amount has been spent on any service during financial year in excess of amount granted by the House for the purpose, committees shall examine with reference to facts of each case and circumstances leading to such an excess, and make such recommendation as it may deem fit necessary. And 242 is the composition of the committee, which consists of leaders of opposition, my lord, and it is a proportional representation, my lord, 242, including all party members, my lord, 242.
So the committee is still dealing with the matter. It is
Yes, committee is examining the matter of CAG report, my lord. Now, under the constitutional scheme, my lord, this very aspect, what happens to the committee report was examined by the Honorable Supreme Court in one of the judgment, my lord. Kindly see that judgment is in my compilation, and the Honorable Supreme Court has dealt with this aspect in threadbare manner. And this compilation of my judgment, my lord, I straight away, because my friend is making certain allegations about the committee, nature of exercise, or making certain things which are not even part of the record, my lord. But be as it may, my lord, what happens to the CAG report before the parliamentary body, my lord, has been examined minutely by the Honorable Supreme Court in Arun Kumar Agrawal's case, my lord. That is part of my judgment compilation at serial number 5, my lord. Kindly see that judgment. And paragraph 54, my lord, at page 79 of the running page, my lord. Page 79, my lord, paragraph 54. The petitioner has placed considerable reliance on the controller and CAG report. Some of the comments in the CAG report were highlighted by the counsel appearing for the petitioner to contain the declaration of fresh discoveries during the appraisal development phases within the delineated discovery development areas amounted to irregular extension of exploration activities, which is not in consonance with terms of PSC. Petitioner has also sought a direction to CAG and Government of India to calculate alleged losses from the payment of 100% royalty and cess by ONGC before Vedanta deal, and for a direction of ONGC and government to recover the excess royalty paid to ONGC from Can India. 56. CAG may be right in pointing out the public monies are to be applied for the purpose prescribed by Parliament and the extravagance waste are minimized, and that sound financial practices are encouraged in estimating and contracting and administration generally. 57. We have come across several instances where considerable reliance has been placed on the CAG report and projecting its gospel truth. Let us examine the role of CAG under our constitutional scheme. 58. The controller
You can skip these paragraphs.
Yes, my lord. Now kindly see 61. The report of CAG are required to be submitted to the President, who shall cause them to be laid before each House of Parliament as provided under 151. In relation to states, reports are submitted to Governor, who shall cause them to the legislature of the state under 151(2). When reports are received in Parliament, they are scrutinized by Public Account Committee. So it will be scrutinized by Public Account Committee of Meghalaya Legislature Assembly. Now 62 is very important. PAC is established in accordance with Rule 308. And in my case, 242, my lord, of the Rules of Procedure and Conduct of Business in Lok Sabha. The function of PAC is to examine the accounts of Union and report of the CAG. PAC shall be principally concerned with the policies carried out efficiently, effectively, economically, rather than merits of the government policy. Its main function are to see that public monies are applied for purposes prescribed by Parliament, extravagance and waste are minimized. PAC has also power to receive evidence, etc. My lord, Durga Das Basu, I am skipping that part, my lord. And 64. Is also the practice which is followed in Lok Sabha, my lord. 64, your lordship may kindly take note. I'm not going through that paragraph. Similar procedure is also by and large.
No, but what is the ratio, Mr. Advocate General?
The ratio is, my lord, that it is for the Parliamentary Account Committee to examine. After examining, then it is placed before the House, and CAG report is not gospel truth. Only one paragraph, your lordship may see, 67. The question that is germane for consideration in this case, whether court can grant relief by merely placing reliance on CAG report. CAG report is always subject to parliamentary debate, and it is possible that PSC can accept ministry objection to CAG report or reject the report of CAG. The CAG is indisputably independent body. So the Public Account Committee will call upon the government, take evidence, my lord, the procedure which is laid down, and then thereafter it will give the recommendation, my lord. The Honorable Speaker, when the matter was placed, my lord, he exercised the power under 131 of the Meghalaya Legislative Assembly rules, stating that since the matter is pending before Public Examination Committee, at this stage motion is rejected, my lord. That power, your lordship will find one.
So here is it before,
131.4 million.
here is it before the committee?
If the report is before committee, report is
No,
before
but
committee. It is
Mr.
not-
Mr. Yobin submitted that it was put up for discussion since there was
No,
in
this is not
attendance.
correct, my lord. No, my lord, the report is placed by the governor before the house and then it is referred to the committee for examination. That is the process.
No, no.
So when
It is,
when the committee sends it to the house, you discuss.
My lord, I was just,
yes, my lord,
just
and this is not 212. Article 212 is a clear bar, my lord. There are 5 constitutional bench judgment on this issue. 212, Article 212, he cannot question. There is no judicial review open to the petitioner to question the decision of the speaker on the motion, on the issue of disallowing the motion, my lord. And that is what London Single Judge has written the finding, my lord. That what he is asking for, as on today, is that judicial review of the decision of the speaker to disallow the motion. And the ground which he is urging, that it is my fundamental right to raise that issue, my lord. Kindly see Article 212. That is the core issue, my lord. Article 212. Whether he can raise that issue is the fundamental. He can't raise. The validity of any proceedings in the legislature of a state shall not be called in question on ground of any alleged irregularity of procedure. What he says that the disallowing the motion is nothing but is substantive violation of his right, my lord. And this is what, my lord, in Punjab,
This
one judgment.
is which article you are placing?
212, my lord, Article 212.
Of the Constitution?
Yes, my lord. There is a clear bar on the judicial review of the decision of the speaker. Lordship has rightly observed that it would amount to transgression of one wing of the government on the other wing. And that is why this Article 212 is placed in the Constitution, my lord. The validity of any proceedings. Your Lordship has the Article 212, my lord.
Yes.
Article 212, my lord. The validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularity of procedure. What he says that the disallowing the motion is open to judicial review, my lord. I will cite only one judgment in my compilation which takes care of all, it refers to all the judgments, my lord. Kindly see page 36. State of Punjab, my lord, and relevant paragraphs are serial number 3, my lord. I have also mentioned the relevant paragraphs, my lord, in my index. Serial number 3, State of Punjab versus Principal Secretary, 2024, 1 ACC 384.
Yes.
Now kindly see paragraph 41, my lord. Article 170 of the Constitution provides that the office of the Speaker and Deputy Speaker of Legislative Assembly. Article 212 of the Constitution precludes the court. My lord, I have referred to Article 212, paragraph 41 at page 54, my lord. Page 54 of my compilation. Page 54, my lord. Paragraph 41. Article 170, your lordship got the page 54, paragraph 41. Serial number 3 is the judgment, my lord. Yes, my lord, 41, my lord. Article 178 of the Constitution provides for the office of Speaker and Deputy Speaker of a Legislative Assembly. 212 of the Constitution precludes the court from inquiring into the proceedings of a legislature of a state, my lord. A corresponding provision with regard to Parliament is contained in Article 122. Decision in Ramdas Atwale, which my friend has been relying, my lord, is significant in that it dwells on the role of Speaker of the House and interprets 122 of the Constitution. Constitution bench observed, the Speaker is the guardian of the privilege of the House, it's the spokesman and representative upon all occasions. He is the interpreter of the rules and procedure and is invested with the power to control and regulate the course of debate and maintain order, my lord. The power to regulate the procedure and conduct of business of House of People vests in the Speaker of House. By virtue of power vested in him, the Speaker is purported to exercise the power under Rule 15 of Procedure and Conduct of Business. Got notice issued on 20th January 2001 for the Secretary General of Lok directing the resumption of sitting Lok Sabha adjourned so and so. Whether resumption of sitting on 29th January was to be treated as second part of 14th session as directed by essentially a matter relating to purely procedure of the Parliament. The validity of proceeding and business transacted in the House after resumption of this cannot be tested on the ground by this court in proceeding under 32 of the Constitution. 42. This court observed under Article 122 the decision of Speaker in whom powers are vested to regulate the procedure and conduct of business in final and is binding on every member of the House. Hence, this court held the validity of Speaker adjourning the House sine die and latter direction to resume sitting could not be inquired into on the ground of any irregularity of procedure. Court affirmed that the business transacted and the validity of proceeding after resumption of sitting of House pursuant to the cannot be inquired into by the courts. This follows the fundamental principle that it is right of each house of the legislature to be sole judge of lawfulness of its own proceeding so as to immune from challenge before any court of law. As whichever Rule 16 of the procedure empowers Vidhan Sabha to adjourn time. So, my lord, the Honorable Supreme Court in recent judgment also said, so far as controlling and regulating the proceedings and including disallowing the motion is sole prerogative and it is protected under Article 212 of the Constitution of India, my lord. And not only that, my lord, one factual aspect also needs to be placed, my lord. My friend's client, my lord, moved a special breach of privilege motion before the House. On this issue, my lord, at page 40A, if your lordship will kindly see factual aspect. He moved at 41, he moved the motion, my lord. And 42, my lord, his motion was defeated. The motion is at page 44, my lord. Defeat of the motion. He has placed it before, and the relevant paragraph, your lordship kindly see 45, where his contentions are recorded, and the motion has been defeated, my lord. Once motion has been defeated by all the members of the House, my lord, and the Speaker has taken a decision to disallow the motion as the matter is pending before Parliamentary Account Committee as per the rules framed, my lord. With greatest respect, my lord, there is no substantive violation which my friend is alleging. 212 is clear, barred, my lord, that those motions cannot be subject to disallowing the motion cannot be subject to judicial review, my lord. So my entire case is, my lord, the finding, if your lordship will kindly see, learned single judge finding is in consonance with law. That your lordship will find at the finding, my lord, at page 53 of the paper book, my lord. Learned single judge has taken note at page 53, Article 212 of the Constitution, my lord. Thereafter, the learned single judge has referred to Rule 138A of the Meghalaya Assembly Procedure Rule, my lord. And after that, the finding has been written that it is not subject to judicial review because it is merely at best, even it can't be called irregularity of procedure, my lord. Paragraph 8, my lord, where the finding of learned single judge is there, page 53, 50, at page 54, my lord. The above quoted rules no doubt allow any member to move a motion for discussion on such matters of urgent as a matter of procedure, and request has to be taken up, which however was denied on the ground that subject matter was under the examination of public so, which is evidence from letter dated 19 February 24 under the caption disallowed motion. Though it is correct that challenge is not on the ground of irregularity of procedure, decision of speaker, however, cannot be said to be unconstitutional to warrant judicial review, notwithstanding submission subject matter involved so and so. So the learned single judge has correctly applied Article 212, correctly applied the power of the speaker to disallow the motion, and has learned single judge has correctly held, my lord, that the speaker has the power to regulate the procedure in the House, my lord. So this is all I have to submit, my lord. I have given a compilation where, my lord, I have given, if lordship kindly see the compilation of mine, my lord. I will not be taking your lordship through the entire compilation, but in compilation, my lord, I have placed the relevant judgment and paragraph, my lord, including the role of CAG in the entire matter, my lord. First is I have placed, my lord, in my compilation rules of procedure and conduct of business in Meghalaya. Then Ramdas Athwale's paragraph, which my friend has relied, I have placed 30, 31, 38, my lord. The recent judgment of the Honorable Supreme Court in 2024, 1 SEC, my lord, 40, 41, 42, which I have placed, my lord, which refers to Ramdas Athwale, my lord. And one short judgment, my lord, of 2014, 2 SEC, page, your lordship will see paragraph 2 at page, my lord, kindly see, the same. The Honorable Supreme Court also rejected similar similar prayer, my lord. At page 57 is this Satish Chandra versus Lok Sabha, those are 2014, 2 SCCs, 178, para 2, my lord. I need not take your lordship through because it is basically referring to, my lord, the principles laid down in Ramdas.
So which cases are you citing? And item numbers 3 and 5 or more?
My lord, I am citing 2, 3, 4 on the issue of Article 2, power of the speaker on 212, my lord. Serial number 2, 3, 4 of my index, my lord.
And 4?
And serial number 4, 5, 6 and 7 on the, sorry, 2, 3, 4, my lord, is on this. 5, 6, 7 are on the power of CAG and the report, my lord. I have already read out, my lord, the serial number 50, serial number 5, relevant paragraph of the serial number 5, my lord, which starts from paragraph 54, my lord, which ends at, and the finding is at 67, my lord.
5, 6, 7.
5, 6, 7, role of CAG, my lord. So therefore, in my humble submission, there is no irregularity, no illegality, and it does not call for interference of this honorable court, my lord. Learned single judge has applied the relevant laws and taken into consideration the law laid down by the Honorable Supreme Court in dismissing the petition. And moreover, my lord, prayer, if your lordship will see the prayer. What is the prayer? That prayer also in the writ prayer was to direct that the motion to be taken up, my lord. Kindly see. So that direction to the assembly to take up the motion, my lord. Kindly see the prayer at page 29 of the writ petition, the paper book, my lord. Prayer of the petitioner, my lord. And not only that, my lord, I say for one more reason, my lord, that petitioner has not placed the fact that he has also moved Loka Yukta on similar allegations. And Loka Yukta has also rejected his complaint, my lord. But so therefore, it is of more of a political nature, my lord. CAG is represented by the leaders of opposition. CAG is also discussing, the PSC is part of PSC composition. PSC is always headed by the leader from the opposition, and it is a proportionate reservation of the assembly members, my lord. And PSC is part of the assembly debate only, my lord. He has ample opportunity to raise all these issues, but for the political reason, my lord, or oblique reason, he is raising all these issues.
All right, Mr. Abdul. Anything in reply? Just 1 minute, nothing else. You have
My
to
lord,
say-
my lord.
You wish to say anything?
My lord, I like to reply by Rule 130A, my lord. The Rule 130A of the Business of Rules, my lord.
Yes.
Rule 130A, my lord, may I just read? Special motions to get precedence over other motions. Whenever any report, my lord, whenever any report, it says any report would mean a CAG report also, my lord, or any matter of public importance, my lord. The learned single judge has rightly pointed.
Any report means the report has been mature by consideration by the committee. It cannot be a kind of a premature report.
My lord, this is a report of the Comptroller and Auditor General submitted in exercise under the provisions of the constitutions, my lord. So now, my lord, and the Rule 241, as I've said, that is the rule of the PSC, my lord. But in Rule,
You see, like a conveyance.
my lord,
Conveyance is executed, signed,
my lord,
but then it becomes final when it is stamped and registered.
stamped and registered.
It is like this. The report has come, it goes to the committee. Whatever the committee says, good, bad, indifferent, thereafter the report attains finality.
My lord. My lord,
We'll get an opportunity at that time.
my lord, of course, my lord, I will get an opportunity at that time, my lord. That is not denied a fact, my lord. But since when, my lord, because this is exactly what is going to happen, my lord, to this report also, my lord. It's not going to see the light of the day, my lord. 2022, my lord, if a learned advocate general can answer.
That is not your case, that the report has been put into cold storage by the committee.
My lord, that is not my case, but my case is only, my lord, when I have moved a special motion under Rule 130A, my lord.
The question is whether that motion is premature or not. Because 15th you placed the motion, 19th.
My lord.
The reply was that it is before the committee.
Committee, my
You have been informed that it is before the committee.
My
So
lord.
it cannot be placed.
My lord, my lord.
So your counter reply should have been that you tell us when the report is released by the committee so that we can take steps and give us leave to move a fresh motion.
My lord, my lord.
We will go into all that.
My
All right,
lord, my lord.
please take down.
Yes, my lord.
Hearing concluded, stop. CAB.
My lord.
Grateful, my lord.